Brain death is a medically accepted concept, but it is just that, a concept. It is not real death. Taquisha is alive and has always been alive, and this decision does not change that.
That's Stanley Stewart, just hours after learning that a judge has ruled his 27-year-old daughter, Taquisha McKitty, is neurologically deceased. That's brain dead. Taquisha spent the past 9 months here at Brampton Civic Hospital in the ICU, her family fighting to keep her on life support, arguing that she was still very much alive. Today, the court ruled that she is in fact dead.
Only God knows what. Tomorrow she could have woke up. With the next 6 months she could wake. We don't know that, so that's the unknown.
Taquisha McKitty was rushed to hospital last September after suffering from a drug overdose. She never regained consciousness and her doctor declared her brain dead. Her family challenged that in court and got an injunction to keep her on life support. All the while, her heart continued to beat, her hair kept growing, and her limbs sometimes moved to the touch. The family argued that according to McKitty's religious beliefs, death can only occur when the heart stops beating, and the doctors should have taken that into account before declaring her dead. Justice Shaw disagreed, writing, "A body can be maintained for an indefinite period of time after a declaration of brain death. This could have a significant financial impact on the healthcare system if a body that is biologically or physiologically functioning is to be maintained on mechanical ventilation until such time as the heart stops beating." At common law, death includes brain death, and brain death is to be determined based on the medical criteria as set out in the Canadian Medical Association Journal guidelines.
The notion that doctors should be the ultimate and unrestricted authority in determining death raises several complications. It potentially puts vulnerable Canadians at risk of abuse because it means that doctors can effectively determine death and can do so without oversight and without consideration of the values under the Canadian Charter of Rights and Freedoms.
Carrie Bowman is a bioethicist and says cases like these are extremely difficult.
There's all those questions whether it is the right thing to do to keep someone alive under these conditions. But there's the question of that, and then there's the question of who should decide whether it's the right thing to do. Is it a family decision or is it not?
Scher believes that the judge considered the financial costs of the decision and of keeping people in McKitty's situation in similar states.
Part of the rationale for that was a goal of trying to ensure that the costs would be contained relative to the treatments that may be required for those who may otherwise meet the criteria for neurological death but nevertheless are biologically alive, such as our client Taquisha.
A spokesperson for Brampton Civic Hospital says that staff there feel for Taquisha's family, stating, "All cases of this nature are tragic and our hearts go out to the families and loved ones in these situations. While we will not comment on the specifics of the case at this time, we can say that this process has been very difficult for everyone involved. William Osler Health System will continue to follow the direction of the courts in this matter."
If it were you and you had a chance to live, would you want people to give up on you? That's a fundamental question. People have come out of coma after 20 years. And for no explanation of the doctors, they don't understand it. But what we do know is what was supposed to happen has not happened. They said her brain would liquefy. It hasn't happened.
Now, at this point, it is status quo for McKitty, meaning that she can remain on life support for up to another 30 days. And then if the family chooses to appeal this decision, well, she could stay in hospital for several more months. For more on this story, head to citynews.ca.